Good afternoon. It's so nice to see all of you here. Talking about an issue that affects us all, and that is what happens if we lose our memory and our personhood, and what happens then. How many of you are here for the first time to a Hemlock meeting? All right. Well, welcome. The Hemlock Society of San Diego has been around now since 1987. And we have meetings every month, and on alternate months when we're not here, we do the Right to Die Film Festival. So that means that every other month we show a film pertinent to the right to die, and there are a lot of them, and they're terrific actually. And we don't do it here, we do it at the Mission Valley Library usually. And so our next one, which is also the third Sunday, will be the movie Honey. Anybody see the movie Honey? It was only shown during the Italian Film Festival, and then just for one night. It's about a young woman who helps people die in Italy. So, very interesting topic, and what happens to her, and what's it like to do that. So I hope you come. It's also free. So our mission here is to expand the rights of people at the end of life so that they can die peacefully the way they want to, consistent with their own values and beliefs. And of course, we've just passed a milestone in California, passing the End of Life Option Act. And it's finally going into effect June 9th, which means that somebody who's terminally ill can apply now so that the first actual giving a prescription by a doctor can occur not before June 9th, but you can be lined up and even go through the 15-day waiting period. The law is complicated and restrictive, and in Hemlock of San Diego plans to have volunteers that will help you work with the law so that if you need to use it, you can do it without a big hassle. Lynn is sitting over there, Lynn Calkin, there, who is taking all our phone calls now from people who have inquiries about the law. And we think it's very important that you now talk to your doctor. Even if it may not be the same doctor that you will use when you're dying, or maybe, but to raise consciousness in the medical community that there are a lot of people out there who would be interested in using the law if the occasion arose. So please, we have a little script that's on our website, hemlocksocietysandiego.org, about what you should say to your doctor. You know, not walk in and say, by the way, doctor, when I die, would you help me? Be a little more subtle than that. But get some idea from your doctor whether he or she is unalterably opposed, no, never. Then you might start looking around. Or, well, I don't know much about it, and then we can send somebody to talk to your doctor about what the law is. Or, yes, I'd be willing to help, and then we'd love to know who your doctor is. We will have a list, but it will be confidential. Your doctor will not be listed in the New York Times, but if somebody does need a doctor who's willing to help, we would like to know that there are doctors out there. The law is just beginning here in California, so it's going to be a while for doctors and hospices and hospitals to get familiar with what's involved. And we hope it's not too complicated for people to use, because it's a very important law for the first time to be able to get help from a doctor. We have volunteer forms back there if you're interested in helping us reach out to the community in any way that you are able to. And we'll be doing some training soon. We hope to be working with Compassion and Choices, who's also been doing training and working with hospitals and doctors. So that's not our program for today, but every program we have will be talking about this because it's so important. Today, I've been involved in this movement for some 30-something years. I started at age 3. And what I hear from people always is, well, being terminally ill is one thing, but losing your memory is another thing. And what happens if we have dementia? Is there some way, what can we look forward to? What it would be like if we were placed in a memory unit? And then the other question is, what if we don't want to stay in a memory unit once our personhood is gone? How do we get out of it? So I hope we'll be able to cover these topics today. And Ms. you moderate. I'm about to introduce Dr. Mitsuo Tomita, who very nicely assembled this panel. And if there's enough chairs, I'm going to stick around here so I can ask them questions too. So this is Dr. Ms. Tomita on our board.
Thank you, Betty. Well, I'm really pleased that these three women have agreed to be resources for us. I'll have them each introduce themselves and explain a little bit about their background and their role. We have Linda Cho with the Executive Director of Stellar Care, a residential facility. Amy Abrams, who is with Alzheimer's San Diego, the local Alzheimer's group that has separated from the National Alzheimer's Association. And then Ann Barber, who was with
Silverado.
So, okay, good. Well, who's going to start first?
Oh, we'll just go down the line, doesn't matter.
Okay.
Just introduce myself
Introduce yourself a little bit about your day job.
Okay, thank you so much. Please be advised, we are totally unscripted here, so we're winging it. My name is Amy Abrams. I am so delighted to have been invited to come and hopefully be able to address some of your questions here today. As Dr. Tomita indicated, I'm the Education and Outreach Manager for Alzheimer's San Diego. We're a local nonprofit organization formerly known as the San Diego chapter of the Alzheimer's Association. I've been with the organization for about a year. My background, I have a Master of Social Work and a Master of Public Health. And prior to joining Alzheimer's San Diego, I worked as a certified professional care manager for about 12 years. So my work in that capacity really informed a lot of what I do today. What I was doing back then was performing in-home assessments with individuals, most of whom I would say, had Alzheimer's or some other form of dementia, helping families put together a care plan, bring in whatever resources it was they needed. So in-home care, meal delivery, placement in a residential care facility, connection to hospice, whatever that might be. Today, I am the education manager for Alzheimer's San Diego, so what I spend my time doing is educating the community about what Alzheimer's disease is, what dementia is, importantly, what it isn't, hopefully dispelling a lot of myths about the disease. There's a lot of misunderstanding about it, clarifying for people that it is in fact a terminal illness. That's a little known fact about Alzheimer's disease. And then working with diagnosed individuals, working with family care partners, training professionals in the healthcare industry, within social services, within residential care facilities, training individuals in how best to ensure quality of life throughout the span of the disease.
I'm Ann Barber, and I work for Silverado Hospice as a social worker. Have a Master's of Social Work degree, and then I also work with Death Cafe, if many of you are familiar with that, so bringing awareness of death and dying to the community. So I started out in long-term care in nursing and was actually on a path to become a nurse, and kind of took a hard right and decided I actually really wanted to be more part of the mental health part of things and part of resources and talking to families and providing education. So I'm here in both of those capacities, and in my day-to-day with hospice, have a lot of conversations about exactly what we're going to talk to. That's what the social worker in hospice, we wear a lot of hats, but the conversation about how to help a loved one who has dementia and making end-of-life decisions is really one of our primary roles.
Thank you. My name is Linda Cho. I'm the Executive Director of Stellar Care. We are a large assisted living facility specializing in memory care. We have over 100 residents, all diagnosed with some sort of dementia. I work with these two lovely ladies in the Alzheimer's Association and is on the advisory committee there now. And we work very closely with the hospices. There is a hospice waiver that we are required to have in order to have people who are in the last stages of their lives. So we work with Silverado very closely. We deal with end-of-life issues almost on a daily basis. And I can't speak loudly enough about the need for advanced care directives that are in place, that are very clear, and the wishes that the residents have prior to being diagnosed with dementia is so important, because once there is a dementia diagnosis, there's no capacity to make decisions at that point. So making sure that your wishes are written down and it's clear is so critical, because we rely on that. And as a licensed facility, we have to abide by the written word of what's there. So I want to encourage all of you to think about all those issues. Thank you.
So what happens to a demented patient who winds up in a memory unit? Anybody?
What happens as in...
What happens once they're in a memory unit? I thought Liz was coming up here to moderate, but she disappeared.
Like in terms of an advance directive, or?
Well, what should be in the advance directive, do you think? Yeah.
I'll let hospice answer this as well, but for a memory care unit, there needs to be an advanced care directive specifying who the power of attorney will be, particularly the power of attorney for health, because that person is going to make all of the choices as far as medication management, the degree to which the illnesses will be addressed, abiding by the resident's wishes, but the power of attorney has total control. They are the alternate for the demented resident. So you must think about who you want to be making your choices, and we turn to them for everything that we do. We will call that person to talk about the condition, changes in condition, the need for hospice later on. So all those things are addressed according to the specified wishes and the power of attorney that's in place.
So for me, when I think about someone preparing their advance directive, what you touched on about who the agent is being probably the most important part of that, because there's not really a way that you could actually write every single scenario down and how you would like your agent to act on your behalf. So what you're looking for in a healthcare agent is someone who shares your philosophy. So one thing that I found is I actually have had quite a few patients where the agent was somebody who was not related to them. And that actually works really well, because when you are asking a daughter or a son or a granddaughter, should we give antibiotics for pneumonia? And it's kind of all those little gray areas. There's a lot of scenarios that come up that you really couldn't predict. Even if you try, there'll be things that will be developed in the future. There'll be technologies that don't exist now. And so the person who is asked that question, they're going to be asked that question by somebody who is going to have their own philosophy, their own perspective. And so what you really want is you want somebody who, when you pick the person that represents you, that they actually would make a similar decision and not have a lot of emotional turmoil about what's the right thing or the wrong thing. And often a family member is going to be the person who's going to have the most turmoil in that situation. So it's something to think about, whether a lot of times people pick, well, I'm just going to put my oldest child, that'll be my first healthcare agent, and then my alternate agents will be my second child and my third child and my fourth child. Kind of almost thinking about it as if it's a will that they're preparing and they're picking an executor. But really what you're looking for is a really thoughtful decision to make, to actually think about who is the person that if I don't have capacity, I feel would make the same or similar choices in this situation for me.
I make one point of clarification. A diagnosis of Alzheimer's or another type of dementia does not automatically mean that in that moment you no longer have decisional capacity. That is determined by the attorney that's helping you draft the document. So Alzheimer's disease, other types of dementia, these are long, slow, progressive illnesses. And in the early stages of the disease, most individuals are still able to very clearly understand the consequences of completing an advance directive, of naming a power of attorney for healthcare or for their estate, for their finances. So we spend a lot of time coaching families through this process. It isn't too late. If you don't have those documents in place, you can still get them in place if you want to update them in light of this new diagnosis. In most cases, not every case, but in most cases, the individual with dementia has plenty of time to make a thoughtful decision, get those documents updated, and make sure that they reflect what they want. So we offer, at Alzheimer's San Diego, we do offer a monthly class, a free class taught by an estate planning attorney with elder law experience, where we walk people through what are the critical documents, what conversations do you need to be having. And it's not just family caregivers that come to that class, it's also diagnosed individuals who still want to be a part of it. To Linda's point, at a certain point, absolutely, as the dementia progresses, one will lose decisional capacity. And at that point, if you don't have your documents the way you want them, it is too late. So we do want people to be having these conversations right away, but if you or someone you know is diagnosed with mild cognitive impairment or early stage Alzheimer's, it isn't necessarily too late.
I think this group doesn't want to get to those middle or later stages of dementia where one has lost all that capacity. So with your experience, what do you suggest for us that don't want to get to that point where we don't recognize our family or what those criteria are? What are the good examples of what you want to write in an advance directive or otherwise instruct your family or friend or fiduciary to do that? What's some good examples?
Oh, that's a big question. I would say, I think to your very good point, you want to give your agent as much flexibility as possible. I am always against asking somebody to make a promise to not put you in a skilled nursing facility, to make a promise not to put you in assisted living or memory care, because you just can't predict the circumstances that they will be facing, financial decisions. It's really difficult for a care partner who feels bound to a promise that they made to somebody. That's a difficult position to put somebody in. But I would say, I mean, just thinking through how could you minimize the chances that you're going to end up in a facility that you don't want to be in? Is that the question?
Once you're in there, how do you get out?
Well, I've been on the other side of that one as well. Once you're in and you don't want to be there, how do you get out? That's what our ombudsman is for. That's such a tricky legal question. If you don't have legal capacity, somebody else is your decision maker. So you've got either a power of attorney, you've got a conservator. That is somebody else's decision to make once you have been determined to be incompetent. But hopefully it doesn't get to that point, to try to backtrack it a little bit. If you've had good, thoughtful conversations, if you have visited, if you have interviewed home care companies, if you have visited assisted living and memory care facilities, and you've got a clear sense of what you do and don't want, have conversations with the people that are going to be named as your agent. Let them know. Whether or not you clearly put that in your documents is a very personal decision. But I do think it's important that people understand, I want to be in my own home as long as possible. What do you mean by that? If it's going to cost you $10,000 a month in in-home care expenses to stay at home, is that still what you mean? Right? It's not that it can't be done, but it's very expensive, it's difficult. So let's have a conversation about what you really value. Right? Do you want to sort of burn through your estate? Many people do. That's not a judgment. You just want to be really clear as the decision maker, is this what he or she really meant when they said they wanted to be at home at any cost? Is that really what they meant? So be very explicit. Have realistic notions of what it really means to take care of a person with dementia through the end of life. It's very intense. It's very heavy, intensive caregiving. Providing care in the home is very difficult compared to providing care in a facility where the staff are fresh and have changed shifts every 8 hours, and they're really trained in how to deal with communication and behavior challenges. So I guess I would suggest that families just enter into those conversations with a really realistic perspective about what the long-term care system really looks like, what it costs, and what's going to be possible for you.
And so I think too, when we talk about, once you get in, how do you get out? But also I think the idea that really bothers people when you break that question down is the idea that you're in a long-term care facility and you may be, if you're going to be there for a very long time. And what are the things that kind of could keep someone in there for quite a long time? When hospice comes in, which is, when it's reasonable to a couple of medical professionals, a couple of medical doctors, that within 6 months, if the course of your illness progresses, that you could pass away, that you could die. That's the definition of when hospice is allowed to come in and provide services. And so the first thing that the hospice team does is they take a look at all the medications, and they look, and on average, we're usually seeing people with 12 to 24 or more medications that are prolonging their life. And so once someone has made that decision to go with hospice, we take a look at those, and it's like, well, what's providing comfort? What can be removed? And I think when it comes to that time before hospice, that really needs to be a part of, I think, your planning. I think all of our answers in terms of what to do are all going to be about being proactive. It's very difficult to be reactive. I think that's why we're even here, is because it is something to plan ahead for. So when you're planning ahead and you're thinking about all the different types of medications and all the different types of treatments, the people that are in the memory care centers and in any long-term care, in any hospital, any medical provider, most likely they went to school to save lives, to prolong life, that's really their mindset. That's why they got into the industry. And so it is very hard for them when they have someone who has maybe moderate dementia to say, okay, but do we continue to give course after course of antibiotics? They used to call pneumonia, used to be called the old man's friend.
Yes.
So if you were not passing away of any, you'd have any acute illness, but you would get pneumonia, maybe you weren't able to fight that off, and you gently went into the night. Nowadays, it's we fight it. It's kind of, a lot of people, it's like, of course, antibiotics, no one would even consider not, and that's, again, one example, but to really think about, again, it's about sharing your philosophy and having someone, it is going to be the person who's representing you that's going to be supporting those decisions.
Excuse me. None of us wants to really go to the hospital setting and be there for a long time, or be in a skilled nursing setting, but that's the reality of life. Is when we get ill, we do go to hospitals and go to skilled nursing to recover. I have had one physician say, people look at cars more intensely and the decision that's made than to shop around for hospitals when you're looking at different insurances. And I would say that same thing needs to occur with assisted living facilities, because we're talking about the ability to make a decision that if every one of us would want to stay in our home for as long as possible, that's a given. I have a mom who's 80 years old, very vibrant, and she would never think of moving into our lovely building, and we don't want her there either. But when there is a need, when it is no longer feasible for someone to keep a 24-hour caregiver at home, or for the children to take care of their parents, mom or dad with dementia, then the hard decision has to be made, and to think about what kind of a setting you want, because there is a variety of options. There's smaller communities with personalized care. There are larger communities with lots of activities and socialization to meet the various needs. There's a whole spectrum of dementia, from early stage dementia with short-term memory loss and forgetfulness, to end-stage dementia. And when we're talking about end-stage dementia, we always look at the dignity factor. When making decisions, when all dignity is lost, and there's no recognition, and there are some behaviors that are so contrary to how we were as an individual, that there is absolutely no way that this person would want to continue on. How do you want the end-of-life decisions to be made? As a facility, we do not have any kind of leeway as far as helping make those decisions. by law, we have to make sure that we do everything possible to make sure that food is offered to you. The hydration aspect is very important. So my experience has been, we've had a wonderful, wonderful family member who was so involved with her mom who was placed and came to the building and did activities with us, and she was a nurse practitioner. When her mom started to decline, she asked us to stop feeding her. And as much as we understood her loving decision, we, as a facility, she was not on hospice, could not, and there was no, she still had the ability to eat. She was much more forgetful, and she was in bed more than she was. But the daughter said, I want you to stop feeding her. And we had to say, we don't have that ability. It wasn't written down anywhere. We have to, by law, make sure that we do everything we can to offer her food. And we said, if she says she's hungry, what do you think? And she says, no, I don't want her fed. And that was not a decision that we could abide by. So, especially with nothing in place. And so those kinds of things are things that I think the families have to understand. In a licensed facility, we are very limited in what we can do.
Now that triggered a lot of questions. I saw there.
Those are questions that we contacted our attorney about, and it's unclear. It really is unclear. Because as a facility, we are opening ourselves to a legal dispute by other family members. So, I don't know the answer to that.
Well, now you just gave me another.
I was just going to say, I think really the line you want to walk with that is comfort versus cure. I don't think there's really any medical facility that would let someone feel hunger, because it's such an uncomfortable feeling. But if they could feed them to the point where there's no hunger, perhaps it's like a high nutrition shake or something like that. As long as the person isn't suffering, I doubt that you're going to have somewhere that would really, even if it was in writing, allow someone to suffer with hunger. But it doesn't mean they have to be, full.
And if I could just add that this is why hospice is so important. Had that person had a palliative consult or been on hospice, there probably would have been much clearer guidelines about when it is and is not appropriate to feed that individual.
Joy?
So to put a little bit of a spin on Larry's question, okay? I have a two-part question. One is, if the family, maybe you could bring this back to your lawyer at some point, but if the family were willing to sign a release to say that we are all in agreement with this, would that make you feel differently?
It really comes down to our residents' will. How is that determined? What the family decides is very different from if you have a very clearly stated, but then when do you, because we have residents with dementia who live wonderful lives with us. They go on outings and they have dementia, but they recognize families. So just because you're diagnosed with dementia, you're allowing your family to say stop feeding? That's a very, so that has to be very clear. But as Anne said, hospice is probably signing on to hospice. Because basically, hospice has determined that there is 6 months or less to live. If that determination is in place, then hospice takes over.
So my second part of that question then is the distinction between artificially or hand feeding versus putting the food and drink within reach, even if the person, so that you make, like if a person put into their advance directive that I do not want to be for artificial, I don't want artificial nutrition and hydration, and I don't want to physically be forced food. I want food made available to me nearby within reach. would any of you be willing to honor that advance directive?
That's very tricky in the advanced stages of dementia because an individual may very well want to eat, but if I'm thirsty and I see that drink of water, I may not have, in the late stages, I may not be able to recognize that that is water, that that's going to quench my thirst, and very likely I'm going to be unable to take it and put it into my mouth. So in the late stages of dementia, simply having food and drink nearby is not enough. So what you really have to offer the food. You have to offer the beverage. They can still, in the very late stages, as the person's body is shutting down, they will reject food. They will not eat, but they may not have the capacity to just because it's offered, pick it up and take it. It's a nearly universal symptom of late stage dementia.
Okay, so last question, but I have a feeling I'm speaking for a lot of people in this room. So what is the answer? I mean, if someone's put into a locked facility and there's been a judicial thing, let's put that one aside, okay? Let's put a situation where someone is in an unlocked facility. If I'm the professional fiduciary responsible for helping someone in this situation, is my recourse to take them out of the facility and put them in a private home with 24-hour caregivers so that they can honor what we're talking about here? Is that the only answer? And I guess, A, is that an answer, and B, is that the only answer?
I'll start. I think I would guess that if you're taking somebody home and providing 24-hour professional in-home care, they're going to have the same dilemma. An agency that is trained in caring for people in the late stages, they're still going to make the offer of food unless the person is on hospice, right? And that's in the directive that that the only way for them to eat or drink safely is through tube feeding, and that is clearly documented that they do not want that. Then you can very clearly stop offering food and water, but really until that time, I would think any home care provider, any residential care facility is going to be in the same dilemma.
I don't remember, I don't think I mentioned that I was an ombudsman at one point for long-term care, so where you're going to cross over is into the arena where you could have a government official saying that would be neglect or abuse. So it's really that fine line. I think if you're always gearing towards comfort, you're not going to fall into that area. It doesn't take a lot of food for someone to be comfortable, for someone to not have hunger pains or to not feel thirst. Doesn't necessarily the same amount of food that might sustain you for months and months and months and years, but it is going to be a balance. So even in a home setting, then it would move to adult protective services. There is always going to be a regulatory agency that's going to say that no food and no water would not. Go ahead. Oh, you want to call someone else?
Thanks. This was prearranged. I'm not crashing a party. My name is Stan Turman. I'm a psychiatrist and a bioethicist. I've worked with 3 attorneys, actually 4. One is Michael Evans, well known to many people in this group. One is Thaddeus Mason Pope, who's definitely the leading bioethicist attorney in the country. He's in Minnesota. And 2 others. And so we've tackled this problem, and it's been so interesting for me to hear with a professional point of view at this, which has some degree of uncertainty and some degree of helpless or hopelessness. And what I've done is I've written 3 books, and I've developed a decision aid tool which is called the My Way cards. And, but the legal basis for all of this comes from constitutional and common law, where you are the king or queen, the sovereign of your body. You can decide what enters it and what doesn't enter it, and you can decide that no one is going to invade your bodily integrity without your informed consent in advance. And in fact, when I add those 2 words in advance, now I'm talking about a living will. So one of the nation's experts on voluntarily refusing food and fluid if you don't have dementia, Judith Schwartz, recently gave a very nice presentation to the Alzheimer's Foundation of America, and she said a living will is a blunt instrument. And Charlie Sabatino, who's the president of the American Bar Association's Division of Aging, I quote him from a couple years ago at a Pulse conference. He said, living wills haven't done diddly squat in 30 years. And I think both of those statements are not true. Because there are some living wills that do the job. And the one that my colleagues and I have worked on for since 2009, called the My Way cards, is a very precise instrument. It gives you 48 conditions, and for each condition you decide whether you want to be fed and treated for as long as possible, or if you want natural dying. And the third alternative is that you don't know, you let your proxy decide. So what is natural dying and what is its legal premise? Food, you are all correct. You must offer food and fluid. You must put it in front of the patient. It must be within the patient's reach. But if that patient has a refined advance directive and a living will that says, if I meet these criteria by a set of those 48 conditions for which I said, don't invade my bodily integrity, don't put a spoon in my mouth with food and fluid on it, then you're obligated to respond to that. That is a higher priority than adult protective services or the regulatory overseers of your institutions as to whether you are providing appropriate care. So, that's a refine. What I did was I took 3 times 3 times 3, and as far as my calculator would go on my cell phone, when I got to 20 of those multiplications, I already had over 3 million variations. 3 billion. And so that's how specific, clear, and specific and individualized this living will can be. And for example, one of the aspects of indignity is if you're incontinent times 2 and someone else has to change your diapers. But as I've been doing hundreds of these living wills using this instrument, some people say, that's not a big deal. There's staff who've been trained, they can clean me up, they can put a freshener in the air, and I'm good to go and enjoy my family when they visit. And I might enjoy my family even if I can't recognize them. And so you can really have nuances. And so there are 2 kinds of proxy directives, and you won't hear this from an attorney. One kind of durable power of attorney for health care says that this is the person I want to speak for me. If I can't speak for myself, I want this person to make all the decisions. Pros and cons. Physicians love it, attorneys love it. One person, everybody has immunity. It works. It's simple. It's really tough on the guy you appoint sometimes to make a life-determining decision. Angst, is now the time? Would Sally really want to die now? How do you know? And so that's okay. So the other kind of the power of attorney is where you have a very refined living will and you say, my proxy agent has a job to do. And that is to make sure that other people honor my wishes. That's the job. And some of the questions, I could go on for a long time. I don't know how much time Vince wants to give me, and I'll be glad to answer your questions if you have, either during or after the session. I'm not running off. But one of the things that came up was if you don't have a living will, if you don't have a proxy directive, durable power of attorney for health care, are there no choices until you get pneumonia? And sometimes it takes 3 to 4 to 5 years to get pneumonia. And I have developed a technique. It's called the consensus of substituted judgment, where you form a decision committee and all the people who are concerned about the patient, go through the same 48 conditions in these My Way cards, and if they can agree on those conditions, sometimes they have to massage them a little bit with a psychotherapist, facilitator, social worker, then they say, we agree, then you can say, this is really what is best for the patient right now, what the patient would really want. Because they knew the patient before the patient became ill, and they've all agreed that that's what the patient would want. Now, how do you convince a doctor, the doctor who comes from, who's a director of hospice, for example? And there are two ways, and we do this now. We excerpt from the Probate Code of California certain sections of the statute that says, yes, you can rely on next of kin to make life-determining decisions. And yes, you have immunity. So even if you made a wrong decision, and you found out that, for example, someone was conspiring to get the estate a larger amount of it sooner, or wanted to run off with the nurse, or anything crazy like that, if it's in good faith, they cannot sue you in civil court, doctor. They can't sue you in criminal court, and your license can't be sanctioned. And then we provide for the patient something like I just said right now, a script. Because they're going to be nervous, and how are they going to explain this to the doctor? So in non-legalized terms, here, doctor, read this, and let me explain what my understanding of it is. You really can do this, and it makes a difference. So ideally, you want to do the natural dying living will while you have capacity, and add layers of strategies to make sure that it will work. And if you've missed that window of capacity, and you happen to have, or a relative of yours who's already in a long-term care facility, a memory unit, there are still options that you can do.
You guys want to comment
I'd
on
like to have some reactions from the...
Sure, yeah, I think you said it very well, that as long as you've done that planning in advance, absolutely. You know, I hear you reflected back a sense of hopelessness, and absolutely that is not the case. The situation that Linda was describing was a person who did not have documents in place giving them authority to withhold food or liquid. In a situation, this is why we do the advanced care planning classes. In a situation where a person is diagnosed, we want them to have very explicit conversations about what they do and don't want, and get it in writing. It can't be implemented unless it's in writing, but it absolutely can be put in writing, and it should be what your wishes would be.
Excuse me. Is there a document that is available for the average person to get what he's talking about, filled out, all the 48, without having to go to 10 lawyers to have it done?
Absolutely, that's what you're
Where do
talking
you
about.
get it?
Yeah, that's what he's talking about.
Yeah.
Where do you get that?
Very briefly, just one.
Yeah, no.
Caring Advocates is a nonprofit organization which I founded in the year 2000, and they have the instrument that you
Say
want.
it again, please.
Caring Advocates.
Caring and...
Yeah, and I have cards with me if you want. And by the way, if any of you have psychotherapists, social workers, or psychologists, or other whom you trust, and you would like to have them help you in the planning, Caring Advocates has moved to its next phase, where we are now training other healthcare professionals to do what I've been doing personally for a long time.
I was on it.
I was wondering if you have the probate codes, do you know them?
Yes, I do.
And also, you said there's something you can even do if you've missed that window of capacity.
Yes.
Could you talk about that?
Yeah, let's hear.
Okay.
I will.
All I was going to add was just, in addition though to your document that's your legally binding documents, we've been talking a lot about that in the law. Also though, why not record it in a journal? Why not put it in a video? Why not make other records as well that maybe are not legal, but what about your own person actually speaking? We're so fortunate with technology today that we actually have the capacity to record ourselves. Actually talking about in this scenario and in that scenario and really trying to convey that philosophy. You do need the legal paperwork, of course, but why not also enhance it with conversations with loved ones so that there really isn't a question about what would she or he have wanted at that point. That's all I was going to add.
I'm so glad you mentioned that because it's a routine strategy that we use. Not only do we have the written natural dying living will, but we also do an interview where we record the person on video. And what I've found is that people in this, who are bright, who are informed, like all of you in this audience, can do it. But sometimes there's a little nuance that you can, maybe you change your mind a little bit if you have an interview. And then, for people who are already diagnosed with early dementia and still have capacity, and I agree, most of them still can complete these documents, the tool, the decision-making tool, My Way cards, is at the 3rd grade level of comprehension in terms of its short, simple sentences, and it's every one of the conditions is illustrated for extra clarity. And I've worked with early dementia patients and they can fill it out. And then you know what they want.
There's a question in the middle there.
One barrier
You can certainly draft an advance directive that says you need 2. And you can certainly draft an advance directive that says that this document itself becomes effective only when I have lost capacity. But the law says only your treating physician, one person, the person who's currently treating you. And I teach decisional capacity evaluation to a variety of healthcare disciplines, and it's not that hard, and if you move, someone else can do it, or the record can be there. And in fact, when I interview someone, and they go through the 48 cards and they explain with nuances what they want and what they don't want, as far as treatment for each one of these conditions, I then, it takes me about 1 minute and 10 seconds on average, say, John Doe has decisional capacity to give his informed consent for natural dying. Bingo. And it's been consistent over the last few months as I've been discussing it with him. And his family is in agreement. So you put everything like that on a video. And by the way, I have about 75 videos on YouTube. YouTube/Dr. Terman, my last name, T-E-R-M-A-N, Dr. Terman. And you can see one of those decisional capacity evaluations about a minute. Yes?
Lots of information. Lots of information. For me, it's almost too much information, but I would like to ask about the bottom line again. If I do everything that's been recommended, if I put in my directive that if I become demented, please, I want to die, please do not offer me food or drink. And if my advocate has that in her hand and shows that, and then will you offer me food and drink?
I'm not a provider of care, so
That's outside of scope.
I mean, I can give a general response. Yeah, I think what you said, the language here matters. You said, if I become demented, I want food and water to be withheld.
I want to die.
Right. Becoming demented, you can absolutely still have full decisional capacity. You can still drive a car. You can still have a job. I could have dementia right now.
If I become mentally incompetent.
So,
I mean, pick out a word. Tell me what word to use.
yeah, that's
This is a very challenging, and I've worked on it since 2009, 2006, a very challenging when question. Every living will tries to answer 2 questions. What do I want or not want, and when? And with dementia, you have to be really specific. And that's why you have to say, you know, like if I'm lashing out at people who I've loved for my entire life and I just seem to want to hurt them, you have to tie me down or sedate me with chemicals. That's a deal breaker. So if you have 48 conditions described this crisply, then you know that you've reached the when thing.
You really would have to be
These
that
people
specific.
are still obligated to offer you food and fluid. So that's what natural dying is. You say, don't stick a spoon in my mouth. That violates my bodily integrity. But you have to put it in front of me. And then I want you to discontinue all other kinds of high technology medical treatment. And I want all the comfort care. Now about hunger and thirst. I know this from the bedside, and I know it also from personal experience, as well as the literature. I fasted twice. Once for 4 days and once for 5 days. No food, no fluid. And one of those videos is up there the second time I did it. And I can tell you that it's not very hard. Hunger is not a problem because your metabolism changes to what's called ketosis. And that provides you a mild euphoria and reduces hunger. And if you still have some uneasiness, then you can have sedation. But thirst is a problem, but fortunately it's a problem that can be solved. And we solve it by giving every person who wants what's called a TRAC, thirst reducing aid kit. And there's nothing you can't buy in the drugstore by yourself, but it reduces thirst in a variety of ways very effectively. And I've been at the bedside of people who've had advanced directives and they were honored and who didn't have thirst, didn't have hunger. In fact, my mother died. Did you know that?
No.
Yeah. And so he was my first bioethics mentor. He directed the dying of his mother, Virginia, by voluntarily refusing food and fluid. And he himself died that same way just a few days ago. Very sad. And I was there, and at the very, very end, hospice came in with a little bit of lorazepam and fentanyl. But up to that point, he was doing fine, and that is so typical. And then some people I've seen don't have any need for narcotics. They usually take a little bit of, and then they go to sleep naturally, because that's what happens when you medically dehydrate. So it's not that bad a deal. It's a very peaceful way to die.
Any comments?
I would encourage you to find out about the various stages of dementia. Just because a person is, okay, I'm demented, I want to die, is a huge statement. We have, if you go on our website, there is a YouTube video of one of our residents, and we have conversations. There's coffee time upstairs, and she's talking about her marriage, and she's funny. And this is a lady diagnosed with dementia. She couldn't live at home. She wouldn't be able to find her way back. But she's in an environment with her friends where she can share jokes about her marriage and her kids. And if you looked at that video and said, well, she's ready to die, she would probably slap you across the face if she met you. She's having a grand time with her friends, and she's enjoying the moment, each moment. She enjoys her family. She may forget the visit afterwards, but she enjoys her family, she enjoys her grandchildren, and to say that, okay, she has dementia and, you know, maybe her family can make that decision is really tough. So for us, we see the whole spectrum of somebody who's diagnosed with dementia who still, to me, lives a very full life. Then there's the end-stage dementia where people are handling their own BM. This is when I say you have to be exact in your wishes. The dignity factor is probably the biggest thing. If there's all loss of dignity, it's probably something you have to think about. But just because, okay, I have dementia, I want to die, is just such a vast, big statement for your family to wrap their mind around. So I think everything we're hearing today is pointing to the fact that you need to be very specific about your wishes. Not just, I'm diagnosed and then I don't want to prolong my life, but at which point you need to find out from the Alzheimer's Association and Alzheimer's San Diego about what dementia is and how long it could be and what does it require for a diagnosis and what the various stages are. And then, of course, the alternative is qualifying for hospice care. What does that involve?
No. But. Still, the bottom line is, you will offer me food and drink.
We will probably be offering food unless you are on hospice. Unless you're on hospice, we are obligated to provide that to you.
But on hospice, I not only have to be demented, I have to be within 6 months of dying.
Well,
There are specific hospice criteria for dementia. So dementia is a little bit different from, say, cancer, where the timeline is a little clearer. So they work out the hospice criteria for dementia is things like the number of infections you've had, if you've lost weight, a certain percentage of your body weight within the last 6 months, if your vocabulary is down to 7 words or less. There are other types of criteria that they use. So because the timeline of end-stage dementia is much grayer than it is in other terminal illness, they have their own set of unique hospice criteria. It's frankly not all that difficult to get qualified for hospice with an Alzheimer's or other type of dementia.
Thank you.
Yeah.
What is the distinction between senile dementia and Alzheimer's?
So Alzheimer's disease is one type of dementia. Senile dementia is actually not a term we use anymore. What we used to call senile dementia, we now understand to be Alzheimer's disease. So Alzheimer's disease is one form of dementia, one cause of dementia. So dementia is the umbrella term that refers to, it can be caused by 50 to 60 different types of things, including there are medical infections, there are short-term sort of pseudo-dementias. Alzheimer's disease is a progressive terminal form of dementia. It's by far the most common. About 75% or so of all people with dementia have Alzheimer's disease, but there are many other causes. So dementia is not a specific diagnosis, it's a syndrome.
We're going to have to be in the front row next time.
Hi, my question is probably more for Dr. Gersh, but it certainly is a wonderful milestone that we now have the right to die law, and I commend the Hemlock Society for all the work they did to help with that. But is there anything being talked about of amending or adding to the law for dementia or for severe physical handicap where you may not be within 6 months of dying?
There's plenty of talk about it, and most of it goes on here. Hemlock has always believed that the criteria of terminal illness is not a valid one, because there are people suffering from chronic illnesses longer and more severely than people suffering from terminal illness. So we have always wanted to expand the criteria. And it's one reason we work with Final Exit Network, which does not use the terminal criteria. Whether it's going to happen in our lifetimes, I don't know. If you go to Europe, the criteria never has been terminal illness. It's always been unbearable suffering. So in Switzerland, Holland, Luxembourg, and Belgium, it has nothing to do with terminal illness. It's not the duration of the suffering, it's the quality of the suffering, how much you're suffering. So that criterion was borrowed from hospice, 6 months or less to live, but I don't know that it has much to do with the situation of people who want to die. So sometime we'll have another program on Final Exit Network and what it does. Compassionate Choices does not like us to talk about Final Exit Network because they want to use a medical model and just for people who are terminally ill. So that may bring us into conflict with Compassionate Choices, which we don't want to be, but we do believe that that criterion is not particularly reasonable.
In California, we call this conservatorship. I don't know what the language was in that particular case, but absolutely, a person who becomes conserved is essentially being sued for their own civil rights. Basically, somebody has to kind of take them to court. So absolutely, in California, anyway, I can't speak to any other state. The individual who is becoming conserved, if somebody's suing for conservatorship, petitioning for conservatorship is the technical term, but it's like a lawsuit. Yes, they are notified, they are actually called to come to the courtroom, where they don't always do that, but absolutely that wouldn't happen without the person being notified, if I understood the question correctly.
Yeah, more or less. Also, nobody in the family, I mean, it was a large family, knew what had taken place.
In California, I can't speak for other states, but in California, it's a very big deal. It's a lawsuit with the plaintiff and a defendant, and there's an attorney assigned if they don't have their own attorney to actually defend, and the job of that attorney is to defend that person's capacity. And it's actually really difficult to get a decision, at least in my experience with all the conservatorships I've seen go forth. It has to be overwhelming evidence. So that's one thing that we have some good laws in California that try to prevent that kind of thing from happening.
Good.
Yeah.
Just as an aside, I used to be a probation officer, and in the 70s, the law changed in California. I can't speak for other states, that attorneys were no longer going to do that, mainly because that was on the bottom of their pile of things to do. So in our case, our probate judge had a good relationship with the probation department. So we handle that. Other counties, social service, and that type of person handle it. I just wanted to clarify that.
Yeah, and really what attorney, really, a lot of good attorneys will advise, try to do anything but a conservatorship if there's any way to work it out without that. Let that really be your last resort.
Jody, do you want to add?
The person is supposed to be notified of it. They're also supposed to have an attorney who represents them, and oftentimes there's a guardian ad litem to represent them. So there are protections in California, and there's pretty similar protections, although maybe not exact, in other states.
Good.
Yes?
I have a question about the in-home facility, the assisted living facilities, and that is something that hasn't come up yet. What about calling 911? I know you're pretty careful, you don't want anybody to die in your premises, or you're worried about lawsuits, but it's a question that has bothered me.
Hospice is 911, but I'll let you speak about what's the non-hospice scenario.
Yes.
Again, we are a licensed facility. We do not make decisions we're not a medical facility. That has to be very clear. We are like a large family member. So we will feed you, we will help care for you, we clean your apartment, we give medications, but we are not a medical facility. So we cannot assume that you're going to be okay. So if you are on the floor and that there was a fall and we feel there's a fracture, we're going to have to call 911. If it's a simple illness, we contact your physician. But if you would call 911 from home, we would call 911 from the facility. If you are on hospice, if the resident is on hospice, then we would call hospice. Hospice is our 911. They will send the nurses out so you don't have to be transported to the hospital.
You want to talk about that?
Yeah, I think one thing to understand too about the dementia population too is how traumatic it can be for them to have to go to the hospital. So hospice, of course, encourages calling us instead of calling 911. But even in this scenario, it's like trying to treat where they are.
Absolutely. We do a lot of education with families about the documents that would get filled out when you move your loved one in, or when you move in yourself if you're moving in of your own volition. There used to be a form called the Preferred Intensive Care, and I think those are still around, but often now the POST document tends to be used more, so that you can actually direct the facility about, do not hospitalize, do not call 911, but really their hands are really tied. If it's a medical emergency and you're not on hospice, if a person falls and hits their head, they really have to call 911 for licensure requirements, unless they're on hospice. But you have these conversations, you should be having these conversations with the facility upon move-in about what you are and are not going to want.
Just to re-emphasize what you said is very important. The new form that's widely accepted is called the Physician's Orders for Life-Sustaining Treatment, abbreviated POST. And that tells emergency medical services personnel, paramedics, firemen, and so forth, exactly what you want. You want to be resuscitated or not? You want to go to the hospital or not? You want intensive care or just focus on comfort measures only? And what I do with people is I take that post form, which has been criticized by many as being like another blunt instrument, there are 3 or 4 boxes you check, and I add about 12 different orders to it so that it can apply to people who have advanced dementia. Because it's a legally recognized form. If you have that form, all other healthcare providers must honor it, except that one of the ways they can honor it is to change it if they're not. So that's possible. And what I do is I have a pouch that people can wear. And we fold up the post and we put it on their, right on their chest. And Caring Advocates, by the way, is one of 3 organizations in the state of California, and we do it in other states as well, authorized to issue DNR medallions, so that when you wear a piece of a dog tag, stainless steel, which says "Do not resuscitate," their law says that paramedics have to hire to that too. But our medallion also has a 2-dimensional barcode that can be scanned by a cell phone that can show these little videos, including the video of your my living room.
By the way, did anyone see the ad in the in the Reader this week about today's event? No? Yes? Thank you.
This lady right here.
Oh, what's that?
Her hand up about a half an hour.
Yeah, I know. I'll do that next.
There's another one over here.
I agree. The ones in the back row are getting short shrift. I will address that next. Thank you.
I regret being.
I don't think there was a question
Okay.
for me. So,
I can
but
comment
yes.
very briefly.
No.
In my clinical experience, people don't care what the diagnosis is. If they can't function, they can't function. If they're suffering, they're suffering. And I agree with Faye Gersh that the Europeans and finally the word unbearable suffering is the criteria. Whether it's Lewy bodies or PECs or vascular, you're suffering. Or chronic traumatic encephalopathy, which we're going to see a lot of from the football players, even from high school and college.
If I could just add one point. There is every reason to seek a diagnosis, and because some types of dementia are in fact treatable and reversible. Most of them are not, but some of them are. And if you are diagnosed with probable Alzheimer's disease and it turns out it's actually vascular dementia, you don't want to be taking one of the Alzheimer's drugs. So there is every reason to, if you doubt the diagnosis, to seek a second opinion. The research shows that physicians are about 90% accurate. It is absolutely true that an autopsy is still the only 100% accurate way to know. You have to look at a slice of the brain upon autopsy to look for those plaques and tangles. But in fact, physicians are pretty close. 90 to 95% of the time they are accurate without having taken a scan of the brain. But absolutely, if you've got a question about the accuracy of the diagnosis, talk to a neurologist, talk to a geropsychiatrist who can tease out that difference between depression and dementia, because the symptoms are very similar. But we strongly advocate for getting a second opinion when you aren't certain.
My question is, we're talking about, okay, we've got our precise document in place. We've done that. We've done our homework and did that. At what point does that spring to our proxy? Who makes that decision of that, okay, the proxy's going to have to take over now? What's the process for that?
Your proxy will be visiting you fairly frequently, but the order to stop assistance with hand feeding and drinking has to be written by a physician. And so the decision is made in a traditional, it's got a great term, it's called shared decision making. And it's between the proxy and the physician, and perhaps other people. in terms of the group. But it's a minimum of those two people who jointly decide that the time has come.
So it would be your regular physician that knew your...
It would be the physician who's currently treating you. It might be the director of hospice or the one who's treating you on a month-to-month basis in the skilled nursing facility or the assisted living facility.
So let's say your proxy wasn't able to be visiting you every day, that you're in the...
I said every week, yeah.
Yeah. Would the facility be, let's say you're in hospital and, you know, you're doing badly. Is the facility going to seek out that person whose name they have on file and say, hey, I think it's time?
They should.
Depends.
Right.
So there are many variations on how living wills and advance directives are written. It's whatever is in your document. And so the lady who before mentioned that some people have that clause that you need 2 medical doctors. Absolutely wonderful advice. Check and see if you have that, because we don't. And I'm not speaking as a legal. I'm not giving legal advice here, but my experience is some people, I'd say just every once in a while I run into that, and having 2 medical doctors just means that, you know, now someone has to go and get a couple different letters from physicians. So it's really how yours is formed, and there are a lot of different versions out there. So it would, some of them would say, I want someone, there's a checkbox on a lot of them that say, I would like my agent to start making decisions for me now, even though I have capacity. So you have everything from that to I need 2 medical doctors to say that I'm no longer competent. So it's really what's in your advance directive or what's in that person's advance directive.
I've seen documents that say my 3 kids have to agree that I lack capacity. I mean, they can be written in, I'm not recommending that, but they can be written in any number of ways.
And then I know there's a difference between being in a skilled nursing facility and a memory care facility. Does the proxy have to be in place for someone to go into the memory care? You go in there when you can't be in the other situation?
Right. Assisted living community, you really don't need any of those documentation because you're making the decision. For memory care, every single resident in our memory care will have to have those documentations in place.
Okay.
And because the alternate, the power of attorney is the person that we're contacting regularly, we will absolutely be talking about the need for hospice when that's necessary for additional services. We will talk about advanced care directives before moving in. We have posts in place prior to move-in. So those are documentations that we require prior to move-in.
Let me get over this side first. Yes?
Yeah, my question is, end-stage dementia is not necessarily hospice, right? Like, you know, you can be in end-stage dementia for a long time before it becomes hospice. Can you guys talk a little bit more specifically about the care involved in people in end-stage dementia, and is it possible to take care of them at home?
It's a great question. So yes, end-stage dementia does not equal hospice appropriate, right? So the last stage, end stage, advanced stage, there's lots of different names for it. It's usually the shortest sort of stage of the disease, but it can be a year, 2 years, it can be extended. What we generally use as the criteria for what's early versus what's middle versus what's late is how much assistance the person is requiring with activities of daily living. Is that terminology familiar? The ADLs are activities of daily living. So when a person is still fully independent with all of their activities of daily living, they're in the early stage. When they require assistance with what are called the instrumental activities of daily living, right? They can still bathe themselves, they can still toilet, they can eat, they can ambulate, they can do all of those things independently, but they need assistance with managing medications, paying bills, using the telephone, transportation, preparing meals, right? That's the middle stage. It's considered end stage or late stage when the person requires assistance with all of the activities of daily living. So they need what we call total assistance or total care. They require assistance to ambulate, to transfer from a seated or a standing position. They require assistance with toileting, eating, not the preparation of meals, but getting the food into the mouth and swallowing. And what's the other one I'm forgetting? Toileting and grooming, personal care. When a person requires that level of assistance, that's what we sort of consider to be the end stage. And then what other symptoms they may experience varies widely. Most people have significant memory loss, confusion, and disorientation in the late stage of the disease. Nearly every patient does. But most individuals will retain some sense of self, right? So we start to see physical changes start to happen. Balance disorders are really significant. It's hard for people to walk in the end stage. They're losing large muscle control, fine motor skill. What else?
Personality changes too.
Yeah, personality changes, but that tends to happen pretty early in the disease process. So.
But don't they also sometimes lose the ability to talk? You become bedridden, and then again, you know, what I'm trying to get is some more specifics, like the real deal. Can a person in end stage be taken care of in a home environment, or do they?
Absolutely. It's difficult. The question was, can a person with end stage dementia be cared for at home? In my years as a care manager, I saw dozens of families do it, and do it very well. People lived a very good quality of life until the very end at home. Most of them went on hospice at a certain point, but not everybody. It's difficult, really. Caring for a person in the middle stages, and particularly by the end stage, is exhausting. It's very difficult work. So unless the caregiver has a good support system, lots of other friends and family, and or lots of professional paid in-home care, it's very difficult to do at home by yourself. I would say it's nearly impossible to do alone, but it can be done with a team. But I will say it's very expensive, hiring in-home care, 24-hour assistance, and generally 24-hour awake assistance does become required. Persons in the late stage have significant sleep disturbance, day-night reversal. They may be up all night. So you really can't do it alone, but you absolutely can do it.
We have about 3 more minutes there, so quickly.
Yeah, my sense is that this process is very, very expensive. And a few of us have mentioned that the cost of this might be too much to deal with. So is there anything in the hopper in the government and in any of the Kaiser or insurance programs, anything that can subsidize, or in some cases I know some countries have actually take care of you in terms of that cost cradle to grave. So is there anything going on right now that will help out in that area?
So for individuals who qualify for Medi-Cal, you have to get on Medi-Cal first. Once you're on Medi-Cal, that is our safety net for long-term care, regardless of whether or not you have dementia. So if you have Medi-Cal, you can qualify for some limited in-home supportive services, which is somewhere between 4 and 9 hours a day of in-home assistance. Medicare does not cover long-term care, and there's not really any plans for that to happen in the near future. Medi-Cal does cover your permanent stay in a skilled nursing facility. If you are not able to stay at home with in-home supportive services, Medi-Cal will pay for a long-term stay in a skilled nursing facility. And as far as things that are in the works, there is a program called the Assisted Living Waiver, which is sort of slowly being rolled out county by county in California. These are administered by states. The Assisted Living Waiver is looking at, will it save the state of California money? Will it improve quality of life if Medi-Cal pays for people to live in assisted living level of care rather than a skilled nursing facility level of care? Which to me is sort of a no-brainer. It's a lower, it's a less expensive level of care, and it's a much more pleasant quality of care to live in assisted living or memory care versus a skilled nursing facility. So we have that today in San Diego County, but it's a pilot project, and there's really only a handful of places where it's available, and there's a long waiting list for it. But I think that's sort of expanding and coming down the pike.
Thank you.
A long time ago, maybe about 8 years ago, I wrote an advanced directive for Alzheimer's. which is useless because it's not legal, but it says all the criteria that you would use when these things go into effect. Can't recognize loved ones, need 24-hour care, etc. And then all the things you would not want to happen, like artificial feeding and hydration, all that kind of thing. And requesting voluntary euthanasia if these things come to pass. There is such a thing as an advance directive for dementia in Holland and Belgium, but it's very rarely used, but it's being used more often. That is, you fill out an advance directive that says, if I can't recognize my loved ones, then I would like to have euthanasia. And then a doctor would give you a lethal injection and you would die. It sounds like what a lot of us would want. And that may, it's being used more now. The problem with it, that the doctors had with it, is because the criteria is unbearable suffering, these people are not suffering. Generally, they are, happy eating their peanut butter sandwiches and singing "Mary Had a Little Lamb" or whatever. And sometimes there is pain associated with advanced Alzheimer's, but sometimes not. But now it's being used more and more, and it seems like a good idea to me. You can buy my advance directive on, we have it in our advance directive collection and also on Derek Humphrey's Ergo website. But again, it's useless, it's not legally binding, but it may be more evidence of what you would want if the time comes.
It sounds like it would be a good conversation tool, if nothing else.
That's right.
Yeah.
Sort of like Stan's My Way cards, yeah. I think time is up.
Yeah.
I want to thank our marvelous panel. Thank you so much. And our great audience, your questions were terrific. And Stan Turman for joining us today. He's been in the audience many times and we haven't really heard a full discussion of his plan for this. Obviously, Stan's work on this and all of our concerns are what happens if we get into this situation and we don't consider living a demented life, a quality of life that we want to continue. And thanks, Mitz, for assembling this panel and for moderating so well. And thank everybody back there for your help.